view it as well. So hit the accept button if you get the chance. So yeah, thank you all for coming. If you haven't muted yourself already, please do so. We're holding this town hall because higher education providers throughout the nation are reevaluating their Title IX regulations because of the new rules imposed by the Department of Education. Some of those regulations are mandatory and others are optional. And today, I'm so happy that we have Valpo's Title IX coordinator, Janelle Ramsel, with us to give a presentation on the potential changes to Valpo's Title IX process. Throughout her presentation and after she's finished, please feel free to ask questions or give your comments in the chat. I'll then read your questions to Janelle after she's done presenting. If for some reason we don't get to your question or concern, we'll reach out to you after the town hall is finished to address that. And while I ask that most of the questions and concerns are expressed through the chat for the sake of time and simplicity, if you'd like to unmute to ask your question, please type that into the chat and then I can call on you and you can unmute. This town, like I said before, is being recorded and it'll be posted on the Student Senate website for your future reference. And with that, we can move on to Janelle's presentation. Thanks so much for coming today, Janelle.
Hi, everyone. Thanks so much for being here so bright and early on a Saturday morning right after school is out. So I really appreciate that. I think you made a good choice because this is a really important decision that's going to have long-lasting policy implications for Valparaiso University. So I'm going to start by giving an introduction to what this looks like, what my role is, what your role is, and what we're looking to decide before we open it up for more questions and discussion. If I haven't touched on something and you want to know about it, Caitlin said you can ask questions in the chat. Caitlin, I don't mind being interrupted, so if it seems really pertinent to what we're talking about, go ahead and jump in. So the way Title IX regulations are enacted on a campus is they are decisions at a federal level. This is a federal law, and they are interpreted by something called regulations. The regulations are also at a federal level, but it's guidance for schools about how we have to interpret this law. The law is really basic. It says you can't discriminate based on sex. The regulations are everything that fill that out. Well, what is discrimination based on sex? That has been interpreted to now mean things like sex discrimination, sexual misconduct, whereas it originated by talking about sports. So it's come a long way from what it started to where it is now. And in 2011, there was a pretty huge cultural shift to moving towards sexual misconduct in Title IX cases, whereas it previously was not. Right now, what we're looking at is a switch kind of back. It's dialing back a couple of the protections that were pushed forward through the Obama administration. So a lot of people talk about Title IX as a pendulum because it once it started talking about and discussing protections for sexual misconduct, it has been swinging from more protections for complainants or people bringing the cases to now dialing back more protections for respondents. So ideally, I think the goal for most people is to find what is the appropriate balance between these two extremes. The guidance document is trying to help us understand what our boundaries are and what decisions we can make. So I'm going to highlight some of the things that have changed for you now that you have a little bit of context of why we're making these changes now. First thing that's very important is these suggested rule changes came out, I want to say about 2 years ago, but they were just formally announced, I want to say about a month ago, and we have to implement these by August 14th. That's on a regular timeline. They're not making any unusual changes. Once regulations are out, the federal government expects compliance on a relatively short timeline. So squeezing all this in is not unusual, but it's still going to be challenging. The first thing that these regulations laid out is that Title IX is now going to be very, very narrowly construed. Whereas before we could look into any kind of sexual misconduct that happened on or off campus, and then it was recommended that we had to look at sexual misconduct that occurred on or off campus as long as it affected educational programs or activities. Right now, the federal regulation says Title IX is not going to include anything that happens off campus, outside the United States, or outside of educational programs or activities. What that means is things like study abroad, any kind of sexual misconduct that happens in study abroad is not Title IX. Anything that happens at a student housing that's not university affiliated off campus is not Title IX. However, we do still have some room to decide whether we want to make it part of our sexual misconduct policy. So we don't have to say we're not going to deal with these at all. We have the ability to do that, but we can also decide, even though it's not Title IX, it can still be within our sexual misconduct policy, and therefore we'll still address it. So that also goes for study abroad. We can also say, even though it's not Title IX because it's outside of a program or activity, it can be covered under our sexual misconduct policy, and we can still address it. The next thing that changes is a couple definitions. These definitions have bigger effects for how we interpret the policy. So first thing is a complaint is going to be limited to only signed and submitted documents. So what this means is if I get verbally told an allegation, I can't move forward on that unless I have a signed and submitted complaint. It formalizes the process a little bit more. Some people might see that as a good thing because then they say, okay, if I'm trying to talk to someone just to get support, and then it goes to the Title IX coordinator, which I'm not comfortable with, I'm happy to know that if I don't sign anything, it's not going forward. So some people might see that as a great benefit. Some people might see that as a very bad downside, because if a complaint rumor comes to me and I have a bunch of rumors, but I don't have any signed and submitted complaints, it's going to be difficult for me to change culture, for me to take action on anything, for me to get witnesses that will cooperate, to have outcomes for someone who's accused. It doesn't mean I have no way of doing this, because if I'm getting a lot of complaints about the same thing, I can always take a complaint forward myself. So there's no extremes there. We don't have to think of this as either I get a signed complaint or nothing happens. There is a middle ground, but typically I go forward with someone's permission that they want to go forward. The signed complaint is a good way to know that I have their permission to go forward, but it does shut out some voices who might otherwise have a very valid complaint. So these things are always happening on a scale. It really depends on what is most comfortable for individuals who come forward. Next thing is I'm looking at my notes real quick. So informal resolutions, we use these already. It's a great way to make a decision, to have some kind of conversation between someone who is accusing conduct and someone who is being accused of conduct outside of a formal hearing process. So we still have the ability to use an informal resolution, which is that process a little bit less than a hearing. But the difference is we can no longer use that for employee and student complaints. So if a student is complaining about an employee, it will have to go through a formal resolution. Some people see that as a very good thing because they see this as an opportunity for now employees don't get to, get a slap on the wrist if that's what the student wanted through an informal outcome. They will have to be held to a very high standard through a formal outcome. Other people are going to say that maybe isn't the best outcome for students who might not feel comfortable in a formal hearing and would have preferred to close this out in an informal hearing. That's one thing we don't have a choice about. We will not be able to move forward Title IX complaints through informal processes. But if it falls short of a Title IX complaint and falls under instead our sexual harassment policy, we will be able to move forward in an informal resolution in that circumstance. So something that would not reach Title IX but would reach sexual misconduct is something like something that was said inappropriately that should not be said, but only happened one time. That does not fall to Title IX. Title IX has to be severe, persistent, and pervasive. So those three factors cannot be met by one-time word or action. Action, let me explain that a little bit more. If someone is touched inappropriate one time, that's going to be a Title IX complaint every time. So any kind of physical touch or interaction raises the bar to Title IX. We can go through formal processes. That means there cannot be an informal resolution, but things like one-time comments that are very rude and absolutely need to be addressed will not reach Title IX. We'll still go forward with our sexual misconduct policy, and we could do an informal resolution. Standard of evidence. So this is one where we have a lot of leeway. We can make changes between two standards of evidence. And those choices are clear and convincing, which is about 75%. Likely that you believe the person accused committed the acts they were accused of, or a preponderance of the evidence. A preponderance is about 50% plus a feather. So what that means is it's almost equally likely that either outcome happened, but it's slightly more likely that the complainant, the person bringing the complaint forward, their version of the events is what happened. So we get to decide between both of those. Some people prefer the preponderance of the evidence because they think they look at the research that says people are very unlikely to bring forward false complaints, and say, know that people are very unlikely to bring forward false complaints. It's better to go with this lower standard. Other people say clear and convincing is a better standard because, first of all, that's what historically the Title IX standard was. It's only since 2011 that we've changed to the preponderance. Second, they might feel that a certain group of people, I've heard people raise concerns that the lower standard is going to make it more difficult for men who are typically charged, and also for Black men who they believe are typically charged more often than other people. At a national level, that might be true. I'm not sure. At Valpo, since in the 2 years I've been here, we haven't had any cases against Black men, so that's not the case here for the past 2 years. But on a national level, I don't have the information to say whether that's true or not. So that might affect what is the best outcome for a social justice outcome. Actual knowledge. So right now we use a term called responsible employees. And responsible employees are people who have to report a matter of sexual misconduct when a report is made to them. This is a huge list of people. It's mostly people who work directly with students. It includes our faculty, anyone who is on staff in a leadership position. It includes RAs, and it's myself, it's the police. What this means is if you as a student go to someone who's called a responsible employee, these people have to pass on your report to me as Title IX coordinator. That does not mean that I have to open a case. That does not mean I'm going to railroad you into going forward with a case. It does mean that if after hearing your case and the details that are known to me, I find that this is a really dangerous situation, such as a rape or a sexual assault, or a drugging and a sexual assault, or something of that sort of nature, I might overrule what your personal choice is in the interest of keeping campus safe from a rapist. But if it's rumors, I don't know who's accused, you don't want to participate, you make it very clear to me you have no interest in going forward, and I don't have enough information to go forward. And even if I did have enough information, I don't think it's a safety issue. So something that would need to be addressed if I was making the choice, but that I am comfortable deferring to a student's choice, such as misgendering. If someone has been misgendered, but they have no interest in telling me any kind of details, so I don't have the ability to address this with someone, and they tell me explicitly, I don't want to go forward with this case, I can respect that, because although it's incredibly inappropriate and contributes to a bad culture, I don't think it has anyone's physical safety in the balance. So again, I'll defer in those cases to what a student wants. But getting more on topic, responsible employees have to pass those on. So if you make a report to your professor has to tell me. If you write it in a journal assignment, that journal assignment is shared with me. And I don't share these around. It's not like, again, it's not like I force you to go forward with anything except in extreme circumstances where there's safety issues. But it's just a matter of thinking through, why do you as a student tell someone that you have a case? Are you telling faculty because you want that faculty person to know? Or are you telling a faculty person because you want help? And if you want help, I would suggest that you like that faculty have to report it to me, because I have the specific content knowledge. I am culling resources at all times, and I work very closely with confidential resources. Faculty aren't any of those. They're not working on this on a daily basis. This isn't their full job. There's going to be a quality difference faculty member to faculty member if those aren't centralized in me. However, if you feel like, I'm not so worried about centralizing, I'm not so worried about the quality of resources, I want to talk to the one faculty member that I want to talk to, and I don't want to talk to the Title IX coordinator, then you might not want faculty members to be responsible employees. So that's a decision point we make. Who are the responsible employees, now called who has actual knowledge? Who do we want to say, if they receive a report, has to pass it on to me? Next thing is the university has the ability to dismiss a complaint if the respondent, is the person who is accused, is no longer enrolled at the institution, or if the university cannot gather evidence. So I'll speak to the second part first. If the university cannot gather evidence, this might be because someone doesn't want to go forward with a complaint, and so they're not participating. If people are being silent, or witnesses don't want to participate. If I'm not able to gather evidence, it's very hard for me to make a case, especially without a complainant or the person who filed. So that's one reason that I can dismiss. That's staying the same. A respondent who is no longer enrolled. This is different. Again, this is a decision point. Under Title IX, I can choose to dismiss it if someone is no longer enrolled, but the university's sexual misconduct policy does not have to have that same standard. We can say that even if someone has graduated, the case is going to continue. So some people might like that because they feel like if they want to come back to the university in a few years and readdress something that happened to them while they were living on campus, they have the ability to. Some people might not like that because they say, why is the university reaching out to me or possibly affecting someone's ability to get a transcript from us if this person is no longer even with the university? And when we're trying to reach people who are no longer with the university, it's also really difficult because we don't have any jurisdiction over them. If they're choosing to no longer engage with us, there's not much we can do. So that's another decision point we have. Do we want to include cases from people who are no longer enrolled or not? Interim suspensions. We have the ability to suspend someone for a short term if we believe that they are a danger to campus. We already do this. That will stay the same. Advisors. This is very different. Right now, everyone has the ability to choose an advisor, and that person can, we call these the discrimination complaint advisors. They are available to complainants or respondents. And it could also be an attorney, but it doesn't have to be. The change is in formal hearings, for Title IX formal hearings, everybody must have an advisor. It's no longer optional. So someone could choose their own advisor like they already can, but this is the part that changes. If they don't choose their own advisor, then the university will have to provide one for them. That will be these DCAs, discrimination complaint advisors. And the role of these advisors is that the advisor must be the person to cross-examine in live hearings. So right now, students in a hearing, a Title IX hearing, will cross-examine one another. What that means, if you're not familiar, is that one student will give their statement. The opposing student has the opportunity to ask questions about the statement the first student gave. In the new regulations, the students will not be doing this themselves. the advisor will ask questions of the other student. And both students, advisors will have the opportunity to cross-examine one another after their testimony. So we have the choice whether we want to limit the role of the advisor outside of cross-examination or not limit the role of the advisor outside of cross-examination. So one argument for limiting the role of the advisor is that some people might be very intimidated by having potentially an attorney talking to them throughout a hearing. So some people might say this is really good for a complainant because if we limit the role of an advisor, then I don't have to be questioned by a trained attorney throughout the hearing. Or if someone has an attorney and another person has a DCA, I would be more comfortable not getting questioned by the attorney throughout the hearing. Other people might say, let's not limit the role of the advisor at all, because that's better for the complainant, because a complainant might feel more comfortable that they could have someone else speaking for them the entire time. And if they don't have the ability to have someone else speaking for them the entire time, then they might be less comfortable going forward with a hearing. So that's a decision point as well. Is it better to have this advisor role unlimited or to limit it? Live hearings, this is also new, must allow for expert witnesses. So as you can hear, the pattern of all these changes is these are getting a lot more similar to courtroom cases. Expert witnesses in courtrooms are someone who comes in and makes a statement of fact about something scientific or something that only someone who is an expert on that content would be able to give testimony about. So for example, if an expert witness might be called in to testify that a student was 110 pounds, she drank 4 shots in 20 minutes, the student can give her own testimony that I was blackout drunk, but an expert witness can say, you know, at 110 pounds, 4 shots in 20 minutes, she would most likely be unconscious. And that's an expert opinion because it is talking about science, or it's talking about something that has some kind of physical basis. So that's one way expert witnesses could be used. In the past, we have not had expert witnesses. This would be completely new. It doesn't mean we have to, but it means that people retain the ability to bring them in if they would like to. There's no decision points on that. That's happening. I just thought I would tell you about that one. I'm just looking through if there's anything else that's going to be interesting or important to your decision making. Appeal rights. So this is similar to what we do already. The only difference is that it's worded slightly differently. So right now, Valpo allows people to appeal the outcome. They allow either party to appeal the outcome. Same thing is going to continue, except the appeal rights are going to be narrowed to procedure irregularities that would affect the outcome, new evidence that was not available that would affect the outcome, and conflict or bias of anyone on the hearing panel that would affect the outcome. So those 3 factors are already in place. The difference is now is that it would have to affect the outcome. So Valpo doesn't have the that would affect the outcome statement right now. By adding that, what that means is it's not enough if there's a procedural irregularity that doesn't grant you an appeal. It has to be significant enough that a different decision might have been made if that procedural irregularity had not occurred. Another difference is that all Title IX training materials must be posted online. So these are the materials used to train investigators and any decision-making bodies. Excuse me. And we will need to retain Title IX records for 7 years. Other than that, most things are looking to be the same, but that really captures the crux of what's going to look different for us. Otherwise, sorry, otherwise our sexual misconduct and discrimination policies are going to look relatively similar. Right now, because our Title IX sexual misconduct and discrimination policy are all one single policy, we also need to determine whether it's appropriate for those three policies to still be grouped together. So one of the benefits of keeping them all together is that it's easier to understand what the procedures are, easier to understand who to go to. It's probably a little bit cleaner. The downside is, as you've seen, the standards for what needs to happen in informal versus formal hearings are very different now between what reaches this high bar of Title IX and what might be considered sexual misconduct, and what was never within those processes, but what was considered discrimination. So a benefit of splitting these out is, if you feel like these changes are very legalistic, I don't like that, or student experience is going to be too constrained in this new policy, or, you know, this is looking like a courtroom, and I think it would be better to have different standards for things that are not required to go through the Title IX process, then that would be an argument for splitting them up. And I think that's about all I have as a summary of the changes. So if there have been any questions or comments, I'm happy to field those.
Awesome. Thank you so much, Janelle. That was really great. You made a very complex topic a lot more understandable. So thank you for your time. Suzanne Brown said in the comments, as someone who reported an incident, I find it to be incredibly important to have signed consent to investigate. I had an experience where a responsible employee reported my experience against my will. It felt very administrative and as though the university prioritized removing liability over my mental health. I simply wanted to talk to an RA about an incident that occurred many years ago off campus. I do believe that the point of telling your story is to reclaim power over it, and I felt as though the power was taken from me after having spoken on this issue. So I guess the question that kind of derives from that is, if a student discusses a Title IX violation that happened years ago and off campus, how does that relate to the new regulations?
So under the new regulations, that wouldn't be a Title IX issue because it's off campus and outside of, it's not including current people who are here. It could still fall, and it would still fall under our sexual misconduct policy. But the question that I'm also hearing is, it sounds like me like it goes to the statement of who should report, who should be responsible employees. I don't see any kind of change in RA reporting. I don't think that that's really on the table because RAs are so ingrained in everyday student life. They have a very high level of responsibility for student safety. But I think that's what her point was that it was incredibly disappointing to her that RAs reported.
Gotcha. And then Liz Palmer asked, how can students who have been assaulted outside of the new university boundaries find support?
Sure. So that is not going to change. If you are outside of the Title IX realm, it could still fall under the sexual misconduct policy. That's part of the discussion that we're hoping to open up right now. Are you hoping that the university will continue to offer support or bring cases through the Title IX or sexual misconduct policy, even if they don't, if they can't be Title IX? So what I'm predicting will happen based on feedback from students and administration is that there will be a split somehow so that sexual misconduct cases off campus could still go through our process, meaning if it was between two students who attend Valpo, then you would have the ability to go forward in a hearing. Hearings are beneficial because it can affect someone standing with the university. There's potential for someone having a no contact order, someone having being suspended or expelled. So that would not really change. And the resources available also would not change. So regardless of when or where an assault happened, The resources available through the SAFE office are not going to change. Those are going to be available to all students at all time. Any complaints that go directly to SAFE do not make it to me unless there's explicit consent. So if you're trying to look for a way to tell your story and to heal from that in a confidential way, there are confidential resources, SAFE, counseling, and any medical provider. Outside of that, those are, if it's made to responsible employees, those come to me. So those supportive resources will not change, even if our policy of what administrative steps we take do have to change.
Thank you. Jennifer Lane asked, although unlikely, how will false complaints be handled? Whether the complaint is true or false, some party loses something very important to them, and I believe that all parties deserve to be heard and respected. This is also something that came up a lot in the comments for the survey.
Sure. So first of all, statistically, false complaints are incredibly rare. There's a research study on this that said between 0 and 8% of complaints of false complaints occur. So that's very unlikely. But with that said, if someone puts forward a false complaint, I think that it's tempered in two ways. First is how we investigate. Our investigative team will reach out to the complainant, take their complete story, and I'll do an analysis of whether their story is going to reach Title IX levels. So if, for example, if they say, someone touched me on the knee one time and I didn't like it, I'm filing this Title IX complaint, that doesn't raise to Title IX. But also if there's something really inaccurate about what someone is saying, for example, I was assaulted on this date, the police look into it and the police say, hold on, I have you signed into class on this day at that time that you said you were being assaulted. So that would be a false report. That's clearly not happening. So the way that the investigation works is that typically the police will take the statement, do investigation on the complainant side, and if it reaches a threshold where they say this seems credible, then they'll begin the investigation on the respondent side. So the respondent, the person being accused, will not even hear about a complaint unless there is enough evidence to continue an investigation. So that's the first protection. The second protection is the hearing itself. So as the hearing goes forward, if the hearing panel says, we don't buy this at all, we think it's very unlikely that this happened, they would obviously make a finding not in that person's favor. And if the hearing panel decides, not only do we not believe that this happened, but we believe that this was recklessly false, you were doing this on purpose, then there will be charges filed against the complainant who brought the complaint forward. So what that means is that individual could also possibly face suspension or expulsion for bringing forward a false complaint. Now, there's a huge difference between a complaint that is not substantiated through the hearing process and a false complaint. A false complaint is something that's done with malicious intent. They know they were never assaulted, but they bring forward that claim as a way to mess up someone's life. That's their entire goal. That's very different than going through a hearing and a decision is not made in someone's favor. In that case, that could have been someone's real experience, but maybe the threshold of the preponderance of the evidence was not met, or there just weren't any witnesses, or the hearing panel didn't know who to believe and found both people credible. So hearings can sometimes be about what evidence there is to support that something happened and not necessarily about what actually happened. So making a finding of responsibility against someone is a pretty serious charge. Making a finding of a reckless complaint is a serious charge. I think that in some ways they kind of balance each other out.
Great, thank you. And then Liz Palmer replied to her previous question. She said that she was mostly worried about houses that sports teams live in and that accountability would be lost. That's also something that came up a lot in the comments to the survey, that students were worried about accountability for sports teams in their individual houses. So how will that interact with the new policy?
Sure. So let me talk first about sport team houses. When students live in sport team houses and those complaints come to me, I work very closely with the athletic director. The athletic director has the ability to shut that sort of stuff down immediately. So what that has looked like in the past is if I hear a rumor even, I'll go to the athletic director and say, this is a rumor that's going around. As you know, this could affect players' ability to play. So if there's any truth to this, they need to take the following steps immediately, even before an investigation begins. So those are not disciplinary charges. We're not assuming that they're guilty. It's just letting them know that this is a complaint that's going around. And if they want to protect their ability to play, serious changes need to be made, if that's only a change in perception. So those, we deal with that pretty swiftly and harshly because athletics has a pretty significant tie to the school's reputation. So I don't see that changing at all. Any kind of off-campus housing, it cannot be Title IX. So if athletes are living together, then it cannot be a Title IX case, but it would still be captured under our sexual misconduct policy. So I don't see that changing either, because we would still have jurisdiction if that's what people want. If people are saying, we do want you to address things that occur off campus, which I imagine most people so far have wanted, then we would still have the ability to change that. The NCAA, which is outside of Title IX regulations, is also cracking down on sexual misconduct. And I'll just share two things that they're doing most recently. First is that every single year, every single athlete will have to sign an attestation form saying that they have not been accused of or been investigated for or found guilty of any kind of sexual crime or misconduct violation under a school's policy. So we'll have the athletic director, if they don't know directly from the student who is right now advised to report to the athletic director if they have a charge against them, or will come from me if it goes to a formal hearing, but not typically if it's an informal hearing. Then the NCAA will catch those at least once a year. In addition, the second thing the NCAA is doing is that they're requiring schools to specifically ask transfer students, incoming students as well, about whether they have any of those three: investigation, allegation, or a finding against them for any kind of sexual misconduct. So lastly, whereas students are given the opportunity to train on sexual misconduct and Title IX policies in the online training once within their college career, the NCAA requires that student athletes are trained every year. So that began last year or 2 years ago, and is an ongoing requirement. So the athletes, in my opinion, are actually held to a higher standard. I think that they also have a little bit more eyes on them because they are so prominent on campus. So they will not be getting off easy if something happens, and that will not change.
Great. I'm actually glad to hear about the mandatory training through the NCAA, because that was something that came up in the comments of the survey too. Students asked if they could attend informational meetings or training. So thank you for addressing that as well. Let's look at the comments here. Jolie asked if you could explain the difference between the Title IX process and sexual misconduct.
So that's a decision point we get to make. Do we want to split up those processes so that all of these higher standards apply only to Title IX and keep our current standards for everything else? So for example, we talked about some of those change points, like The role of the advisor in hearings. If we split Title IX completely off from sexual misconduct, then we could keep our sexual misconduct process as it is and say, you don't need to have an advisor unless you want one. We could say in sexual misconduct cases that are not Title IX, you don't have to file a formal complaint. You don't have to, let's see, what else? The appeal rights don't have to affect the outcome. So all those sort of things that we were talking about are decision points and change points. We have the ability right now to say, okay, if we split these processes, we could keep those in the Title IX process, but use all of our current processes for things that are sexual misconduct. If we group Title IX and sexual misconduct together, we'll have to go by that higher standard for everything. So that means even if it wouldn't otherwise be a Title IX case and it falls under our sexual misconduct policy, if we keep Title IX and sexual misconduct together, then the higher standards apply. So I talked about also the severe, the persistent, and pervasive. And Julie, is that what you were wondering more about, or did I already answer what you were asking?
You answered what I was asking.
Then I'll just end there.
Awesome, thank you. Since there's no more, Liz asks, has it been decided who will remain mandatory reporters?
So that's actually the feedback I'm hoping to get from students. I'm really curious what your intentions are in speaking to different people who are called actual knowledge now. We're called responsible employees. So are you talking to RAs because they're your friends and you want to talk to that specific RA? Or are you talking to RAs because you want to get help? So another thing to think about is if you're going to them to get help and you're saying, I'm talking to this RA because it is who it is and I want to get help. If you're looking for help, the RA is not a trained counselor. The RA, it's also a matter of care as an employer, not me personally, but the university for RAs, because there's things that RAs are and are not trained to do. Counseling is not one of them. Sexual assault response is not one of them. And it's not a matter of training up the RAs. It's not that we're refusing to train up RAs. It's that this is a professional degree that has professional state licensure. This is someone's calling. This is something they go to school for a long time, and they retain a professional license. And it also comes with a lot of benefits. So, for example, professional counselors and the safe advocates, our single safe advocate, Paula Dranger, all have counseling license, which means anything you say to them is completely confidential. That means that even if Paula is called into court, she will not testify about you or against your case. If you report everything that happened to you to an RA and this goes to a court case, that RA is going to be dragged into court and tell your story, whether you like it or not. So there's a reason that we funnel people toward professionally licensed people. I completely understand, and I can understand why people would feel very violated that an RA has now shared their story or that a faculty member has now shared their story. But the opposite is also true. We're looking out for you because if you think this person is confidential, that's not true. So that's why we split it up. It comes to me so that you can decide whether to take action, and it goes to the SAFE office if you decide you're looking for help. It's also, not only is it a matter of training, but it's also a matter of care. It's incredibly, incredibly difficult for people to hear stories of sexual assault. And that's not to say you have to sit with it, because it's your experience. You get to share it how, when, where, if you decide to. But it takes an emotional toll on people. So as an employer, we also need to be looking out for our employees and think, what are appropriate boundaries for them? What are we going to say? Be as helpful as you want, but when you reach that wall, here's the resources available. So there is a little bit of concern about saying, faculty member, I know that you're actually a physicist, but now you need to be a counselor for someone. So I'm really curious why someone would go to a professor, because if you're saying, I want to talk to that professor, I think that's great. I love that you have those good relationships with students, with with faculty, that would be very persuasive to me. But I am also thinking about, but what is my role as the university to protect that professor from being asked to do something that is way outside of their training, and could put them in an uncomfortable legal situation if they're asked to now share your case in a court of law. So I don't think any of these decisions are really black and white, but I would be so grateful for your feedback on the questions that Caitlin and Jolie circulated.
Yeah, does anybody have any comments on what they believe the role of faculty should be in the Title IX process? If so, you can just unmute your mic, because that's definitely something important that we want to discuss. It was in the survey as well. Okay, a lot of people did reply that they wanted faculty members to remain mandatory reporters or have actual knowledge in the survey. And I guess since there are no more comments, I can move on to some questions we had from the survey. Someone said, I really am questioning why you would not have 3 separate processes. Discrimination and Title IX are more aligned than discrimination or Title IX with sexual harassment. I'm curious as to why they're all grouped this way or not grouped that way.
So right now they're all grouped together because the same process and the same rights were pretty easy to give to all 3 processes. They all have informal options. They all have formal options. I think I talked to this a little bit with Jolie's question about the benefit of splitting off Title IX is because Title IX has a very high legalistic bar, and the formal hearing and the rights in an informal hearing are going to be much more legalistic right now. If that sounds like a good thing, then you probably want to capture all of these policies together into one single policy. So they all have this high bar, they all have these legalistic standards. If that sounds like a bad thing and you're thinking, you know what, my school should not be a courtroom, I don't want, it sounds intimidating or any other kind of thing, then you're probably thinking, you know what, Title IX should be split off. And then maybe you would still like sexual misconduct or discrimination to be together because you say, I like how the policy works right now, keep those together. But you might make a switch and say, you know what, Title IX and sexual misconduct are so closely aligned that it would be a bizarre outcome to split those. So for example, we might begin an investigation and I might say, okay, at the beginning of this investigation, this does not seem like it's Title IX, so it's going through our sexual misconduct policy. And then in the course of the investigation, I might find, whoa, this is actually Title IX, so now it has to change and jump policies. Another thing that could happen is if Title IX and sexual misconduct are not split from one another, what could happen is that the exact same conduct that occurs on campus goes through a different policy than the conduct that occurs off campus. So for example, because a sexual assault that occurs on campus would be Title IX, and a sexual assault that occurs off campus would have to go through sexual misconduct. So some people might say that's bizarre. It's the exact same behavior. Title IX and sexual misconduct should go through the same process. I acknowledge that that'll raise the standards of the hearing or actual knowledge that has to go through a Title IX process, even if it's sexual misconduct and not Title IX, but that's the better outcome because these same kind of allegations will get the same treatment. So that's the decision point. Discrimination also runs through, currently, again, these are 3 policies all in one. Thinking about discrimination, some people might say, you know what, if we are raising the standards for Title IX and sexual misconduct and we're not raising it for discrimination, is that, downplaying the importance of discrimination complaints? Is that saying that these are not valid? So some people might see it that way. Another way people might see it is, you know what, these changes that we have to make for Title IX are not common sense good changes. And so if we bring up discrimination to the same level, we're actually punishing students and making it harder for them to go through a discrimination complaint. So it really depends on, do you think these changes are a good thing? Or do you think these changes are creating barriers for students? Do you like the idea that Title IX is in its own world? Or do you like the idea that Title IX and sexual misconduct are so closely aligned that they need to be grouped together?
Great, thank you. Another question we had in the survey, or not really a question, more of a comment actually, is to shorten the time frame. The commenter thought that 60 days was too long of a time and the process should not take that long. What is the probability of shortening the process from 60 days?
So let me give a little bit of context for this. In 2011, Dear Colleague letters came out that said we needed to respond to sexual misconduct incidences within 60 days. So that was the first hard guideline we've ever gotten. Our current policy says 60 days, but if we finish that up sooner, we can always go sooner. And the downside is we can always make reasonable accommodations for taking longer. Reasons we've done that in the past is maybe a complainant has filed and then changes their mind and doesn't participate with us. We can't really go forward if we don't, if there were no witnesses and the complainant is not telling us anything about it. So if we don't have their participation, we're going to go past that 60-day mark because we don't have any investigative assistance. We don't have any stories from them. They might not want to be participating. So our investigators will give time for that student to make a decision. Other issues that have arisen in the past is student breaks. So if sometimes we get an influx of reports over breaks because people are away from the situation, they feel safer, they feel ready to talk about it, but it's hard for our investigators to get in touch with the responding party because they're not on campus. So when they're not on campus and they're at home for break, for let's say it's the Christmas break, if they're not getting in touch with us, that'll stretch out our timeline and our ability to investigate to a pretty significant degree. There are common sense deadlines that I put in place too. So for example, if a student is on campus and is refusing to cooperate with us and they're accused of something, I'll say, okay, we're going to reach out. We're going to reach out in a way that we know we have contacted them. And if they don't respond in 2 weeks, we're going forward without them. So I am able to enforce deadlines so that we can hopefully try to make it around 60 days or sooner. But with a lot of these common sense extensions, breaks, non-participation, it can also go well past 60 days. So whether or not, to speak directly to whether we will shorten this to less than 60 days, I think we already have the ability to complete an investigation in under 60 days if everything goes well. And we do complete those in under 60 days if everything is aligned. They aren't completed when there are extensions for extenuating circumstances. But I don't think that there's going to be support for a timeline that is less than 60 days. And even if we do make a timeline that's less than 60 days, there would still have to be common sense exemptions that would extend it past whatever new timeline. So some people liked 60 days and said, this gives me a good idea of how long these should take. And some people said, I would prefer, I think the wording is reasonably prompt, because that makes me feel like it's going to happen as fast as is appropriate for my case.
Gotcha, thank you. Jewel also asked in the chat, she said, I believe the changes to Title IX are still being contested in federal court. Is there any way to keep the older standards until the court process is over?
That's a really good question and a very good following of those laws. So thank you for that. These are being contested in court. I'm going to tell you, I don't believe they're going to be successful. There's a way that rules have to be published and circulated. These regulations followed all of those. Dear Colleague letters, which were the standard in 2011, followed none of those. They were also challenged in court and were unsuccessful. So I feel like when you compare those two, One followed no rules but was upheld, or actually it was just denied. They didn't make a decision on it. They kind of just kept skirting it and skirting it. And one has followed all the rules. I'm just very personally skeptical. But assuming that I am wrong, we still cannot wait because we are bound by that August 14th deadline. If anything happened that we had not met the August 14th deadline and were sued, we would be in crippling financial trouble. So I'm speaking a little bit now as the school attorney. So no, we can't wait. But if a decision comes out that says these are not, we can't go forward with these changes, I know there's a few things that we would absolutely want to roll back immediately. But until that happens and until we get an injunction from the federal court system that affects the entire nation, because that's another issue. Now I'm just talking about legal stuff because this is a huge interest of mine. If there's right now people are, I can't stop myself. This is like word vomit. I have to tell you about it. Right now people are bringing cases in certain courts, and the courts are issuing injunctions, if at all, for that specific jurisdiction, meaning it doesn't reach us. It used to be that judges were a little bit more interested in making nationwide injunctions. That's just not the case anymore. So unless there's a case in Indiana that is going to bind the entire state or place an injunction on this before that August 14th deadline, we just don't have any authority to not make these changes on, and wait for those outcomes. I will, whoever said that, feel free to call me up or email me if you want to nerd out on this a little bit further.
Awesome. Thanks, Chanel. The next question we have, you kind of addressed this when you discussed the discrimination policy, but someone asked in the survey, does Title IX address homophobia or transphobia? If it does not, does the university have policies to help LGBTQ plus students who may be faced with harassment?
So it depends on what the basis of the harassment is. Title IX and sexual misconduct are sexual in nature. So it's domestic violence, dating violence. Those capture sexual assault. It captures sexual harassment. Sexual harassment is really the umbrella term, and all of these terms follow down from it. So if it is based on sex, so I heard trans, if it's about a trans student, then, and it's somehow invalidating their experience, misgendering them, that would fall under sexual misconduct. It does not reach Title IX. If it's something like discrimination, if it's homophobia, so if something is said based on that person's sex, that might also go through the sexual misconduct. Discrimination could also capture those. It's very fact specific about what could happen. So I think what the person asking this question is like, it sounds like they're trying to decide if we split up these policies, where would those fall? And that's a really good question. It's hard. I'm trying to think through an example. So something, if someone said a slur about someone's gender identity or sexual identity, etc., those would fall under either Title IX or sexual misconduct, depending on how pervasive it is, because it's based on sex. If someone is alleging they were not hired because of their sexual orientation, that would fall under the discrimination policy. So maybe a student is saying, I didn't get this job because I am XYZ identity. I do have to bring to your attention, though, that Valpo is a religious school. And as a religious school, we do have the ability to define what identities we will and will not protect. Right now, gender identity is protected from harassment, meaning anything, if you are harassed based on your gender identity, then that would go through the Title IX case. But if you are alleging you were not hired based on your gender identity, unfortunately, there is no case for you under our discrimination policy. That is not a protected status at this time. Another legal issue is there's a really interesting case about trans rights before the Supreme Court right now. I'm hoping we will see that before October. We should be seeing it relatively soon if you're interested in that sort of thing. And that might have implications widespread. It'll definitely affect public universities. I'm not sure how it's going to be written. It still might not affect private institutions. I'm not sure.
Great, thank you for that clarification. Another question, someone asked if students could have a soft copy of the new Title IX process and regulations. I'm assuming students will be notified when all of this is solidified post August 14th. So how do you plan to communicate these changes to students?
Can I just get a clarification? Does soft copy mean something in particular to you? I don't understand that term.
Yeah, I'm not 100% sure. This is the direct quote from what they asked. I'm assuming it was just aside from them being published on the website, something. Yeah, Jennifer says, I think it means online. So aside from it being published on the website, yeah.
Okay, so I will really only be circulating copies that are finalized. This is the opportunity to get all your feedback. I'm going to be making some choices based on the feedback the feedback I get from students, faculty, and staff, and then with the guidance of my boss and the executive leadership. Then I'm happy to, not only will this be posted online, but it'll also be talked about in the Title IX working group, of which we have student membership, so they have the opportunity to send that out. It's not the sort of thing that I imagine going out in an all-campus email, because I don't think that most people would want to get emails about policy changes, but we will have student members tapped into these policy changes, and I'm happy to also talk through the changes that we adopted or did not adopt in a forum similar to this, if that's of interest. I don't want to take up your time if this is not eventually helpful, but I'm happy to do that if that's also of interest.
Awesome, thank you. I think it would be great if we could have you into a student senate meeting at the beginning of the year, and we could do an open forum too, so students can come. And those meetings will be live streamed too, so if someone can't make it, they can watch it from home and comment as well. When you brought up the all-campus email, I would recommend sending out something. A lot of students want to be informed, even if it's just, hey, there's something new, you can check it out at this website. I know that's something Student Senate has experienced a lot with recent policy changes, and especially with all of the COVID stuff. Students want to hear, even if it is only something simple.
Thank you for that feedback. I had no idea. Everyone has always told me stop emailing, so I really appreciate that. Thanks.
Yeah, no problem. And I think Jennifer just said, yeah, Jennifer agrees. She says that, students like the updates. Yeah, Valpo students definitely like to be in tune with everything happening on campus. Yeah, and Jennifer said also because we sometimes don't know where to look for things, right? So that would be super helpful. I know somebody else asked in the survey comments, they asked if that you could have a training at some point in time during the year, just outside of Student Senate for anybody who wants to come, students, faculty, or staff. Would you be open to doing something like that?
Training on Title IX, sexual misconduct, or on policy changes. What's the scope? Do you know?
I think it would be pretty broad. So kind of like what you discussed today, just a general broad description of what Title IX is and then how it's different for this year.
I'd be absolutely happy to do that. I do onboarding trainings with our employees. So I could do something similar, or I could change it up based on what students are looking for if you have feedback on that.
Awesome. And just a question, are all employees required to go through Title IX training? So
no, we provide online training to every employee. One of the limitations, this gets a little bit into the weeds, but I'll just tell you the overview. One of the limitations of the software that we use to do the online training means that we're not able to branch out who has done it from which department. So while I know which employee has or has not done it, I don't know where they work in the school. So it's a huge administrative burden to break that down. I assign all of these and do all of the work for it as part of my job. and this is not an excuse, but I just don't have the time to break it down further and look up, directory person by person for 1,000 people of where everyone works. So while we do offer it, it's not enforced as required. But some departments do enforce it and require it. So for example, Student Affairs enforces it and requires it. The NCAA requires that all athletic staff is trained annually. So the athletic staff, they have a slightly different training than all other employees or staff. They do that every single year. Everyone who is new to the university is assigned the year that they join. That might not be immediately when they come to campus, but they do receive that within their first year of work. And I also do road shows. So what that means is, I think similar to what you're asking me to do for students, I speak at, I go to the focus fairs, I speak at Welcome Week, I will go when invited to fraternities or sororities. A lot of times people see it as a punishment, so I don't get invited often. I do traveling road shows to departments. So when I started, I went into different faculty colleges and gave presentations. And if there is ever an issue, if I see, oh, there's 3 complaints, that's extreme, that's never happened. But if I see a pattern of complaints in a specific area, I will reach out to them and suggest that I give training there. This year, I'm also giving training to the orientation assistants before they begin at Focus. So I try to find a lot of partnerships and give a lot of trainings, but is it required? No.
Yeah, thank you so much for reaching out to all those different groups and making sure that they know how to keep everybody safe and abide by Title IX regulations. When you say departments, do you mean like colleges? Like, how does that affect faculty? So it would be like the Department of Theology, the Department of Political Science. How does that break down?
I mean, colleges, they have man, I wanted to say departments again. They have college meetings. So Arts and Sciences has meetings of all the deans within that. And then I will speak to those groups or tell them what's available or just tell them about myself so that they know how to reach out with resources. There's also the provost has meetings. I think it's called the Council of Deans or something like that, where I'm a frequent guest and I'll talk about different issues or changes that are upcoming and how I'm getting feedback. My favorite way, though, is really the Title IX working group, because then by having membership across staff and faculty, those people are able to act as the arms of whatever I need to accomplish in a way that otherwise I wouldn't be able to because of just realistic time restrictions.
Gotcha. Thank you for clarifying that. Unless anybody else has any other questions, we've made it through pretty much everything from the survey. I'll give everybody a minute if they want to put something in the comments. All right, it looks like nobody else has any other comments. Like I said before, this town hall is going to be posted on the Student Senate website. So if you ever have any follow-up questions, I hope I'm right to say that, Janelle, people can reach out to you with any questions. And people can reach out to me at senate.president@valpo.edu. If you have any comments about what you liked or what we can improve on for next time, this is our first ever digital town hall. So it's kind of cool, despite the fact that we're doing this under some odd circumstances. So yeah, if you have any other questions, please reach out to us. Thank you all so much for coming on a Saturday morning during the summer. I appreciate your dedication to what happens on campus. With that, I'll let you guys go. Thanks, Gabe. I just saw your comment.
Thank you, everyone.
Thanks, Janelle.
Thanks, Janelle.